All right, welcome back, everybody. This week we're going to do an Instagram live Q&A. My name is Eric Finch. I'm a former USCIS adjudicator and a former consular officer. We're here today on behalf of Boundless Immigration to talk about your immigration application and some of the different questions that you have. We have several questions that we received in advance, and also my colleague will be sharing anything that you asked during the discussion today. So if you have something that you're interested in that you'd like to talk about, just go ahead and leave a comment for us. Just want to stress once again that I'm not a immigration lawyer, and I cannot give legal advice. So anything that you hear on this discussion or that questions that we respond to are designed to just be general information, based on my experiences and the experiences of some of the people that I've worked with over the years in my prior roles in the government. So we've done a few of these now. Just want to say welcome back for anybody who's joining us who's been with us before. For folks who haven't been with us before, just to give you a little context, I have these questions that people have submitted. Some of them are pretty detailed. I'm going to kind of try to give the high level explanation for some of the things that are happening. And, I'll provide some specific information where I can, but I cannot talk about or advise you on specific matters about your immigration status or your case. So please, understand that distinction. All right. So let's go ahead and get started. We had a question here, kind of interesting. Can a non-relative sponsor a Moroccan citizen and get their tourist visa approved? So one thing we haven't talked about a ton on these Q&As is the distinction between like immigrant and non-immigrant visas, and specifically like what you need to do to obtain a tourist visa. So let's kind of get into that a little bit. The question was about sponsorship. So as we're all aware that in order for you to qualify for an immigrant visa and get a green card, or if you're in the United States already, for you to apply for adjustment of status, is that you have what you call a petitioner, right? And for employment-based visas, that would be your employer. And for family-based immigration, that would usually be like some relative. And which relative can ask for who and how long it takes depends on the relationship itself, right? So, the one we deal with most commonly is like marriage-based, green card applications. And for those, obviously, you have to have a U.S. citizen or lawful permanent resident spouse. But non-immigrant visas are quite different. Non-immigrant visas are designed to let you travel to the United States for a specific purpose on a non-permanent basis so that you can do business or attend school or do all these other things that we know folks like to do, go to Disney World. So if that's your intent, you can apply for a tourist visa. Now, a tourist visa has a law that applies to it that's not really applicable to the immigrant visa process. It's called the Section 214B of the Immigration and Nationality Act. And that law basically says that the United States is going to presume that anybody who wants to apply for a visa, a non-immigrant visa, a tourist visa, student visa, there's a few others that it applies to, those people are intending to immigrate. That's what the U.S. government assumes. And because they make that assumption, the purpose of the visa interview or the visa application review process is just to see, based on that assumption and the evidence that has been submitted and what the applicant is saying during their visa application or interview, like, do we feel, are we now confident that that is not their intent? Because again, with non-immigrant visas, you can't use those visas directly to immigrate to the United States. It's not allowed. So, they'll have an interview, a short interview, and talk to you about your financial situation, your family ties to the country that you come from or the country where you're currently residing. They'll talk about, relatives and friends that you may have in the States already, prior trips to the United States or prior travel to other countries. Just kind of give them some confidence that you'll use your visa according to the rules that they've set, right? So where does sponsorship come into this conversation? Well, there is actually a form, it's called the I-134, that is intended to allow somebody to act as a sponsor for people who are going onto the United States as non-immigrants, with a tourist visa in this case, right? So the question I think a lot of people have is, well, what is the point of this form, and what does it do, and does it help the person who's applying get approved, and who can be a sponsor? And generally speaking, this form is not required for any non-immigrant visa except the K-1. Now, why is the K-1 fiancé visa an exception? Well, the K-1 fiancé visa is an interesting visa because it's designed to allow you to go to the United States with the intention already established that you're going to get married, at which point then you adjust status and get a green card. So the reason why they ask for that sponsorship form, and the rules for sponsorship for the K-1 fiancé visa are a little bit different than they are for the actual adjustment of status process. But it's designed basically so that the person doesn't get caught in catch-22, where they don't necessarily meet the requirements for sponsorship in a green card context, but they're already in the United States on this K-1 visa, which only gives them 3 months of duration of status before they're supposed to leave or get married. And in that scenario, they look at the sponsor's income, they make sure it meets a certain criteria, and then if you are able to submit that form with your K-1 visa application at the consulate, then you can be approved and then travel to the United States and then do all the rest of the stuff that you need to do. Now, for a tourist visa, in the past I have seen people who have gotten somebody to complete this form for them. Maybe it's a brother or sister that lives in the U.S. Maybe it's a work colleague or somebody else that's a trusted friend. And there's some debate legally, like what level of responsibility for somebody you take on when you sign this affidavit, but its intent is to say that, and I think it actually says in the wording of the form, okay, this by signing this agreement, you take on responsibility financially for this person should they have some kind of issue or something that requires them to do what would normally be a benefit that was exclusively reserved for Americans, right? Like some certain types of social welfare type benefits and things like that. In practice, I don't know that that's ever enforced, but it is a requirement to actually complete the visa process. So going back to the original question, can a non-relative sponsor a Moroccan citizen who wants to get a tourist visa? Yes, if you have somebody in the U.S. who's willing to sign this paperwork for you, you can complete it and then bring it to your visa interview, and the consular officer will look at it. I will tell you from experience, it doesn't carry a lot of weight because, again, like I said, it's not really enforceable. It doesn't really, give us a lot of information about the sponsor or that relationship. But you can at least put it out there and be like, hey, somebody is at least willing to put pen to paper and sign this thing saying they're going to make sure that I do, I take care of what I need to take care of financially, and we're not going to leave the U.S. government holding the bill. So, yeah, I guess the short answer is, does it hurt? No, probably not. Does it help? Probably not that much help either. So you can proceed according to what makes most sense to you. Okay, next one. We had a question about the NVC. What is the outlook of NVC cases moving forward for those who've been documentarily qualified for over a year? Those people, yeah, I mean, we touched on this in various ways. So for context, the National Visa Center is located in the United States. It's a Department of State facility. And it's basically the clearinghouse where all the USCIS petitions that apply to individuals who are potential immigrants who are still overseas, they have to be communicated some way from USCIS to the Department of State so that they can identify which consulate this application needs to take place at, and get to work with coordinating with the consulate to schedule the interview so that you can get a visa in your hand, right? And we all know that the MVC has a rather large backlog. They report on it every month. While they are making progress in terms of actual numbers of cases that they are processing, they're not making huge amounts of progress against percentage-wise against the overall backlog, and that doesn't feel really great to a lot of people, right? Like they get their petition approved, they get that approval notice from USCIS, they're like, oh, great, okay. And this, for context, this used to be something that happened pretty quickly. You were really waiting on USCIS, and then back before COVID and before the last 4 or 5 years. The things would move out to the consulate and be handled pretty quickly after that point. So I think people had gotten used to that pattern of you wait a long time for the USCIS step, and then things start to happen pretty quickly after that. And unfortunately, that's not the case anymore. A lot of those cases are being sent to the NVC, and then when the NVC looks at the consulate and says, hey, when can we do this appointment? Again, because as we said, these people are documentarily qualified, right? So the first thing NVC did is reach out and say, we need some additional paperwork from you, which you submit, via your account with them. And then somebody will look at it and say, okay, this looks good. So this looks like it's ready for interview. Now we got to work with the consulate and figure out when we can get this person in there for that interview. And it varies a lot right now by consulate. Some places have more or less caught up, at least for the major benefits like the spousal green cards and fiancé visas. Other ones are really short-staffed and are facing really tough challenges getting caught up on the amount of work that built up over the years. So it's going to be somewhat a function of where you're located. Yeah, that's why it's kind of hard to answer this question in general, because there are some people who, depending on where they live or where the potential immigrant lives, are probably still going through the NVC step pretty quick and getting their interview teed up and scheduled, while like other places, it could be like a long process. And you won't, unfortunately, there's not really a good way to verify that. Department of State talks about NVC backlogs, but they don't really talk a bit about backlogs scheduling interviews at the actual consulates. They do publish numbers for non-immigrant visas, so if you want to get a tourist visa or a student visa, you can go to the travel.state.gov website and look up that information and get a general idea of how long you're going to have to wait for that appointment. But for immigrant visas, it's going to be much more around like, when the consulate can reach out to you and like what kind of paperwork and things they think they might need even after the NVC step. So sorry, I know that's not really great, accurate information, but yeah, I mean, I think we can see from the trend with the backlog that Department of State is still facing challenges even up to this day, catching up with the work that is built up. And it's going to be a long process, I think, before they're back to the kind of service standards that they had before the pandemic. Okay. There's a question here. When is the best time to do the medical exam I-693? So every adjustment, most immigrant visas, they're going to require a medical exam, right? And there's a couple different parts to that. The doctor will look at you and conduct the normal traditional exam. They'll get information on your vaccines and then verify you have the proper vaccines according to U.S. law. And this, I think, it's a question for everybody, right? For the people who are overseas, I think usually it's something that's like kind of more done around the time they get their interview scheduled or as they're planning for that step. But in the United States, it's kind of an open question because USCIS has a lot of like sort of complex rules around the timing of this, right? Like you can't do the medical exam more than if some of these regulations have changed temporarily. It's really hard to keep track of all the announcements. But yeah, traditionally you couldn't do this thing more than 60 days before you actually filed your application, which made it tough, right? Because you're trying to get this thing in as quickly as possible, and sometimes you're waiting on paperwork and stuff that makes it harder for you to actually file your paperwork with the government. If you get out to day 61, then that medical exam is no longer valid, and it's not free. You've been paying for this. You'd have to go back and get another one. So a lot of people tended to like either schedule them like really close together once they knew they had all the rest of the paperwork done, or the government also lets you file the medical exam anytime after you file up till the time that you have your interview. So because of those rules and the fact that the medical exam does also expire, and this again has been changed a little bit during COVID, whether that's temporary or not, we'll see. But you only had 2 years from the time the medical exam was done before it was invalid and you had to do another one. So if USCIS took a long time and you did your medical exam before within 60 days of when you filed the case, but it took 2 years to process the visa, then you would arrive at your interview with an expired medical and you have to go out and do that, and it delays everything further. So a lot of people got to the point where they said, well, why don't I just wait and do my actual medical exam right around the time I have my interview so that I could either mail it in with, if there's an RFE request, or bring it with me to the interview. And I can tell you a lot of people did sort of go to that tended to kind of do that. They'd go get their interview notice 2 or 3 weeks out, immediately schedule a medical appointment, and then they'd get that fresh medical exam sealed in their hands. They'd walk into the interview at USCIS, hand it to the officer. Everything looks good to go, right? Okay, so that worked pretty well. So what's the problem now? Well, number of things, right? USCIS during the pandemic, it became really difficult to get these exams on short notice. People were scheduled out months or even years in some cases. So people would intend to do it the way I just described, find out that they weren't going to be able to get an exam before their actual USCIS interview, show up to the interview without it. It doesn't cause your case to be denied necessarily, but the officer will basically put the case on hold until you can get that medical. So now you may have been waiting years already, and now you're extending this process another, couple of months, worst case scenario. And, you also, I think for a lot of people, it does not feel good to leave the interview without like some general indication that they've been approved and that they're going to get the green card shortly after that. So it just didn't feel great in that scenario. Now, what's happening now is, there's been another change with USCIS where they've reinstituted, because of they're so backlogged and, because of all the challenges they've had with staffing and things like that, they've reinstituted a number of interview waiver criteria. Now, those criteria are not public, so it's not really possible for you to know exactly what they're going to look at to qualify you for this. But, a couple of possible scenarios are things like they did make a public announcement that for removal of conditions, in most cases, they were going to apply, again, some kind of internal criteria and then exempt most of those removal of conditions filings from having to do a follow-up interview. And whereas they were doing lots of follow-up interviews for removal of conditions filings over the last few years. So if that ends up being the case, another example is employment-based visas have largely gone back to interview waiver if they have all the other documents and things in them that they need at what would normally be the interview step. So if your case is selected for interview waiver, great, right? Like that, it should just be, they look at it and everything's there. If not, they send an RFE. If everything's good, then no interview. You don't have to travel, 7 hours from where you're at to the field office. And then, you would just get your visa, right? You get your approval notice on your online case tracker, and then your visa come a few weeks later. Now, what's the problem? This goes back to our medical question. If there's no medical in your file and you're not going to have to come in for the interview to give them your medical, your case is going to be delayed, right? Because you don't have everything in there that you need. And this is what USCIS is struggling with now, having reinstituted these interview waiver policies. They're finding out, again, a lot of these cases have been pending for a long time, that a lot of these cases either never had medicals or have expired medicals, and they're having to RFE everyone who didn't have their medical in the file already. And that is also complicated and delays cases and things, right? Now you got 10, 15 cases that an adjudicator is juggling, waiting for RFE responses for medicals. And, everybody's having to get appointments right away because you don't want to delay your visa processing any longer. So going back to the original question, when is the best time to do the medical exam, I-693? That's a personal decision you could make. All the things that I just talked about are still in play. But, it would appear, given these circumstances and the fact that these kind of policies are around interview waiver are going to continue for a while into the future, that getting that medical in there with your initial filing is probably going to be the safest bet if you want to at least give yourself the possibility of getting your interview waived and your green card automatically issued without RFEs. Okay. I had a couple questions come in over the chat. Give me 1 second here. The first question we had is I have a pending asylum case. I got married. I filed an I-130, and they closed my asylum case. Chances that my I-485 interview will be waived. So anything around asylum is always kind of tricky to talk about because there's so many specific things that can happen. But I think one thing to think about is the way from USCIS's perspective, what happens with asylum and that path to possible green card status, whether it be through immigration court or whatever, is really kind of a separate pipeline from a traditional family-based marriage green card adjustment filing, right? So it's useful to think of it in terms of two different tracks of eligibility. And if you think about it in that sense, yes, you would theoretically, if you were being adjudicated as the spouse of a U.S. citizen and you met all the, or an LPR and you met all the requirements, then you would be eligible also for any decisions or criteria around interview waiver. So I do think that's a possibility. Now, that being said, there's obviously more in that A file than just that marriage-based application, right? So if they look at that file and they decide, there's some other things in here that we may need to talk about that may affect your eligibility or things like that, of course they're going to require an interview and make sure that they sort those things out. So, in a certain sense, having more stuff in your file, more stuff to look at, more questions to ask, more possible issues to follow up on, it's going to start to lean in the direction that an interview would be required. But yeah, I don't think on its face there would be any special consideration that said people who are, meeting the requirements for this actual filing of this type of case just wouldn't be eligible because they have this other, because it's not just asylum, right? There's people who file I-140s for employment-based visas and then get married and file marriage-based adjustment applications while those I-140 and even I-485 associated with that I-140 are pending. And, when you get your green card, it's sort of even if you had 2 or 3 other irons in the fire, cooking at the same time, once you get that green card, it's all kind of a moot point. So that's why a lot of people who are in that long, complicated asylee process, you came over as an asylee, maybe you were a teenager or, in early life. And, those things can go pending for 5-10 years. And, life happens in the meantime. It does happen often that people find a partner and get married in the meantime and just eventually end up adjusting on that basis. So yeah, I would say, going back to the original question, I think whatever chance that the interview would be waived would be similar to any other marriage-based, adjustment of status filing. Okay. Next we had, please discuss what's happening with the F2A visa. F2A visa. What's the reason for not issuing an F2A visa, and how long is it going to be? We're stuck, and our family is separated. So F2A is tricky, right? Okay. So for those who don't know, the F2A visa is a preference-based family category visa, and it's for lawful permanent residents who are, people who are already have a green card can file to bring over their spouse and their child. By child I mean unmarried, under 21. And those are F2A categories, right? And it's quite different from an IR1 category, which is a U.S. citizen spouse. Remember, IR categories: U.S. citizen spouse, child, parent, some adoptees adopted by U.S. citizens. Those IR categories don't have caps. They issue as many of them as get applied for qualified people every year, and the only thing that slows it down is the actual backlog of the processing time. Now, everything else, the adult children of U.S. citizens, the adult brothers and sisters of U.S. citizens, spouses and children of LPRs, they are in preference categories, meaning that they have currency dates, and they have to get in line because there's only a certain number of those that can be issued every year. Now, the good news for F2A is that in the recent history, for several years, they have been what they call current, meaning that there's no backlog, and all of the people that apply for those F2A visa categories in that status are able to instantly go around, and they don't have to wait for their priority date to become current. They can immediately turn around and file for the immigrant visa or the green card or the adjustment application. Okay, so sounds good, right? There shouldn't really be any problem then. As long as they stay current, they should be able to get their green cards around, within something similar to the normal process for the IR categories, right? Well, here's where it gets a little tricky. After COVID, a lot of the U.S. embassies and consulates had to prioritize, meaning they had a large backlog of all visa types, and they had to make some decisions about which was going to come first in line in terms of categories, so that they could service the people who, from a certain perspective, had a stronger claim to this benefit or this relationship. And whenever a decision like that is made, it's always going to be for the benefit of U.S. citizens, right? Like if a U.S. citizen is married to somebody and an LPR is married to somebody, and both of those people are in the United States, the U.S. government has to help the U.S. citizen beforehand, right? And I'm simplifying it a little bit. I mean, there's certain criteria and other things that could affect this, but in a general sense, that meant that when a lot of the U.S. consulates and embassies opened back up after COVID, their direction was that they need to prioritize processing the spouses and fiancés of U.S. citizens who were in the backlog first. And far behind that became all these preference-based categories, which were, still looked at and still considered in cases of emergencies and stuff, but ultimately kind of took a step back from all the stuff that they were doing for the U.S. citizens who were requesting benefits. And in practice, depending on the consulate, this could mean that the actual F2As were put on the back burner or given a smaller amount of resources in favor of these other benefits like the IR1 and the K1 visa. So what I think a lot of F2A people are seeing is that, they are here in the United States, they're trying to reunite with their family, and they're not getting visa appointments even in the time frames that other people who are doing the IR benefits are. And that's, again, it varies a little bit by location, but yeah, that's what you might be seeing, and that's why you're waiting what feels like an excessive amount of time for that F2A visa appointment. So yeah, a good example of how, on paper, there shouldn't be any problem here, but when a lot of the things that came out after the pandemic, were kind of unprecedented, and having to prioritize these cases this way was one of them. So yeah, I wish the best of luck, and they will those applications will be adjudicated, but they may take a lot longer than people are accustomed to, and it's going to be hard for you to know exactly what the timeline will be. Okay, and yeah, there's a question from your adjudication experience. How can one prevent a removal of conditions filing from being sent to the field office from the service center? How can you? So this is really about like interviews, right? We talked about interview waiver. So for a long time, even before the policy that was announced in April around ROC and waiving interviews was there was a distinction that was made where they're like, okay, removal of condition under certain circumstances is kind of like a perfunctory step, right? Like if you got married and then you had a conditional green card, and then 2 years pass, you're still married, maybe you have some kids now, everything's going great relationship, then that feels like a pretty easy form to take care of. It's like to the point where some people question why it's even necessary, right? They want to make sure that that USCIS under certain circumstances wants to have a little look back so they can say, oh, okay, 2 years out. Like sometimes when people have just gotten married and they're just getting to know each other and their relationship hasn't lasted that long, it can be really hard for USCIS to make a decision about whether that is a genuine marriage or not. And the thought being, if they get an opportunity to take a second look and have you submit some paperwork at the very least, then it could be easier for them to kind of close the book on the case and give you that permanent 10-year green card. Now, where it becomes a problem is there are other circumstances. Like it is possible that people get divorced in the interim. And a lot of times, if you're divorced, that doesn't necessarily mean they're going to take away your green card. But a lot of times they would want to have a conversation and just sort of like give the USCIS adjudicator a chance to make a determination whether that was actually a bona fide relationship or whether it was just a relationship that was created for the purpose of getting that person a green card. So they would see if somebody would come through the thing and file their removal of conditions application, which is required if you have a conditional green card right before the 2-year mark. They would see that the person was divorced, and they would, after looking at it at the service center, they'd say, hey, let's go ahead and send this out to the field office and have one of the adjudicators there conduct an interview. And I've been through some of those interviews, and I would say in a lot of cases it's pretty easy to kind of hey, a lot of marriages don't last 2 years. It's unfortunate, but it's true. And we would have that conversation. We'd talk through what happened, and it was pretty easy a lot of times to say, oh, okay, this is, life happens. This person is probably fine. Another example would be people who get immigrant visas. So if you got a K-1 or if they had waived an interview at some other step in the process, a lot of times USCIS would use that opportunity at the removal of conditions step to come talk to you, sometimes for the first time. I know one policy that was in effect during the Trump administration, there was a thought that, just because somebody did a consular interview with you overseas to get your immigrant visa, USCIS has never spoken to you, and that, USCIS would like a chance to kind of look at what's going on with your relationship and make sure that everything looks legitimate. So the rule for a lot of those folks was, yes, we are going to send out those immigrant visa, consular processed folks and have them come talk to us at the 2-year mark, and then if everything looked fine, we'll go ahead and go from there. They have backed off that policy now, and I think a lot of those cases are also being considered for interview waiver for the ROC step. So I think going back to the question that was asked, the questioner is looking for some hints about what type of things should be in that ROC filing that may lead to a service center staff making the determination hey, we're not worried about this. We're going to go ahead and approve it here at the service center and not require an interview. And I think it's a good question, but it's also I think one way to think about it is let's just make sure that we cover as many bases with the things that we're filing in terms of paperwork. So, submit a few additional pieces of evidence, look for some solid evidence that would strongly suggest that, if you are still in a relationship, then, you go ahead and send in that evidence, make sure it's up to date, it's current, it covers things like finances, social situation, living arrangements, so that somebody can just kind of look through that paperwork and go, okay, this looks good. For a lot of people, though, it's going to be more a function of what's kind of happened with their relationship, right? So, I would say for folks, I don't have access to whatever checklist they're using to apply this interview waiver criteria now, but I would imagine it's something around what I said earlier about divorced couples, folks who based on the evidence they submit, looks like they may be separated or in some kind of like rocky relationship situation. Like that might be something that USCIS would want to follow up on. And again, like I said, you don't have to still be married to obtain your green card, but USCIS is required to kind of look at everything and make a determination that was a real relationship from the get-go. So I don't think there's anything special you can do except just be really mindful of like what the purpose of that removal of conditions paperwork filing is, and try to meet those criteria as much as you can with the evidence you submit. If that's complete enough, then in most cases, like I would imagine they would waive the interview and let you go ahead and send out that 10-year green card. Okay, I got time for a couple more. Is there a visa I can file for my fiancé in another country without a K-1? I'm a green card holder and not a citizen yet, so is there a visa I can file without a K-1? Unfortunately, and a lot of people don't know this, but the K-1 fiancé visa is only for U.S. citizen petitioners. So that visa is only for that category, and that's a little bit different because we talked about earlier. LPRs can file preference-based F2A applications for their children and spouse. So married, I guess in a nutshell, it's like if you're an LPR, if you're married, good to go. You go ahead and get that thing filed and get your family over here and reunite. If you're just out there looking for relationships and you have a foreign fiance, it's not so easy, right? You're gonna have to find some other way to get them here. And just to kind of help people understand like why a fiancé visa is necessary. Sure, like you can get other types of visas, and you could come to the United States, you get a tourist visa, and meet somebody and fall in love, and do whatever you need to do. But if you're looking at people who already kind of have an existing relationship, it can be challenging because most of the other non-immigrant visas, like I said, are designed for short-term, non-permanent trips to the U.S. And, the Department of State has a rule called the 90-day rule, and it's not 100% strictly enforced, but it's kind of like a general policy that says that anybody who enters the United States claiming, one type of visa or one type of purpose of travel, one type of activity, who immediately turns around within 90 days and tries to do something completely different, like get a job and start working, like get married if that wasn't explicitly authorized by the K-1 visa, then those people, the presumption is that they committed fraud, right? Because surely if something is happening that changes your plans that quickly after arrival, you must have had some idea that was going to happen. Now, that's not applied in all cases. That's not always exactly how the rule is applied. And from a USCIS perspective, it's more of a general tendency rather than a policy. They're not bound by the State Department's policy around this. But yeah, it comes into play like if you come on a tourist visa and then you start working or something like that, and you stay in the United States past your duration of status, among other things, other ineligibilities, one of the things they can apply is a fraud and misrepresentation finding, and that will affect you when you return to your home country and try to apply for another visa. They'll tell you that you're ineligible. And from that point on, for the rest of your life, you'll need a waiver to be able to obtain future visas. So going back to the question that was asked, no, there's not another visa that you could file, because the purpose of the K-1 is to kind of explicitly get around that 90-day requirement. Say, actually, you can come to the United States and get married with this K-1 visa, and you have to do it within 90 days. And then, you become eligible for spousal green card filing and other things that you can do via adjustment of status. So, it could be a challenge. I think people do get caught up in this. Like they apply for tourist visas and then they travel to the United States. And it's discovered at some point they have a fiance there that they're meeting, it happens to U.S. citizens too. U.S. citizens, not everybody knows about this visa process and the fiancé visa. Sometimes they say, oh yeah, just go to the embassy and get a tourist visa, come over and we'll have a great wedding and we'll just go from there. And it's a mistake made out of ignorance of the process more so than, a malicious attempt to get around it, but it can cause consequences all the same. So, there's a couple things, I think what commonly happens with the LPR fiancé situation is, you either go to them in that country or some other third country and you get married. And I know that's a deeply personal decision that is so many other criteria and factors, but, having gotten married, and again, USCIS respects any legal marriage that's legally valid in the place it was performed. So, if the LPR and the fiancé meet halfway in, Fiji or somewhere else that's not part of the United States and get married there according to their local law, you could come back and then file for that person as an F2A now that you have that spousal relationship. But, the fiancé option will be closed off to you. Okay, I got time for one more. There's a question here about priority dates. If the priority date on the I-485 is from 2019 and the receipt date is from 2022, when scheduling the interview, does that matter in terms of getting in front of the line? So, yeah, this one gets into the currency dates and priority dates thing. I think it's better to think about it like this, which is like the I-130 is, if you're in a preference-based category, the I-130 is like what starts your clock. And like that's what, you get that, what you call your priority date. So say you file an I-130 for a preference-based category and, that it's got a 3-year currency date, backlog, right? So you really don't exist in their system because the I-130 petition, all the petitions do is establish the relationship. They're not really about the immigrant yet. They're just saying that like this eligible petitioner, U.S. citizen or LPR or what have you, is saying, hey, I do have a relationship with this person. And then, once that I-130 is approved, it feels like it's part of the same process for a lot of people because for the immediate relative categories, it's kind of happening at the same time. But for most other categories, and it's kind of like one thing happens and then you wait and then the other thing starts, and they're happening like sequentially, right? So in this case, for this question, they're saying, okay, I got a priority date, and I had to wait some period of time before I was able to file my I-485. I waited that time. Once my priority date was current, I filed my I-485. And just like, is that, where does that put me in terms of like prioritization for my interview? And I think in that case, it doesn't really have a huge impact because as long as your I-485 is filed and a receipt number is applied, it falls into the same category as all other 485s, right? Because at that point, it's really just whatever category adjustment application, and it goes through the same process. Now, yeah, they're not looking at the I-130 because that'll be in the A file, but it's already approved. And again, they'll verify that you're current and that you're eligible to file based on your priority date. But then it just sort of goes into the same pipeline. And I mean, this is way oversimplified, but like USCIS is really just adjudicating these things in the order it gets them. So the date that you actually file the 485 is going to be the controlling factor, because then you're outside the currency date and priority date issue, and you're in the processing time issue. And the processing time across all 485s like tends to be somewhat similar. There's obviously some exceptions for some of the other more boutique categories, but it's these family-based like 485 adjustments, like for an F2A, for example, if it wasn't current for some reason, you would just wait that amount of time, file it, and then that 485 just gets slotted in with all the other 485s that are waiting for an interview. And so I would say in response to this question, it's going to be more a function of like backlogs and things at the specific field office where you're planning to apply. That's going to affect it much more than the fact that you had, this preference category application versus something else. I don't think that it's going to help you or hurt you really in terms of like the prioritization for the interview. It'll just go through the normal process like everyone else does. But, like all cases, your mileage may vary. There are some special circumstances and unique cases where things move very quickly. Other ones get backlogged for a long time for various reasons, depending on what's going on at the service center and things. So, everybody's case is really a lot different. Okay, I'm going to go ahead and wrap up there. We do have a couple more questions, but I'm sure we can cover those next time we talk. So just want to thank everybody for the participation. Great questions, great discussion. I love the interaction that we're getting with the folks out there, and I love sharing this information with our community. Keep the conversation going. Reach out to us on social media. Tell us where you're having challenges and what we can do to talk through it. And I'll give you the best answers I can, and hopefully we all learn a little something from each other. So again, thanks again, and I'll see you next time.